A very warm welcome to everyone. It's wonderful to have you join us once again for the second edition of our 15-day online capacity building program on AI technology and law, organized by the Faculty of Law Integral University, Lucknow, and Law Teachers India. This evening, we turn our attention to a subject that feels straight out of the future: AI and robotic law. Questions around accountability, ethics, and regulation in a world where machines make decisions are no longer hypothetical. They are real and pressing, and this session gives us a chance to reflect on how the law must respond to these changes. Guiding us through this exploration is none other than Mr. Rodney Ryder. Mr. Ryder is a lawyer with over 25 years of expertise in technology, data privacy, intellectual property, and new media laws. He is the founding partner of Scriptboard, a full service commercial law firm specializing in technology, new media, and IP. He has authored Guide to Cyber Laws, the IT Act 2000, E-commerce, Data Protection and the Internet, the first section-wise analysis of the Indian IT Act 2000. He currently serves as an advisor to the Ministry of Communications and IT on its implementation. He counsels clients from startups to Fortune 100 companies, represents them in litigation on technology, data security, law enforcement compliance, and IP strategy, and serves on the boards of leading companies. He is also frequently interviewed and quoted by Indian and international media on these subjects. Educated at St. Stephen's College, University of Delhi, Mr. Ryder graduated with honors in history, securing the gold medal for first rank in the university, along with prizes including the Westcott Memorial History Prize and Percival Spear Memorial Prize. He later studied law at the Campus Law Center, University of Delhi. Mr. Ryder has also been nominated as a leading lawyer in intellectual property, technology, communications and media law by Asia Law, Who's Who Legal, Asia Legal 500, amongst other international publications. He has been listed as one of the India's leading lawyers in the 40 under 45 study conducted by Who's Who Legal in United Kingdom. In 2021, Mr. Ryder was listed in the Super 50 TMT list of leading TMT lawyers in Asia published by Asian Legal Business. His second book, Intellectual Property and the Internet, has been cited by the Supreme Court of India in its landmark domain name judgment Satyam Infoway Limited versus Sifinet Solutions Private Limited 2004. He has taught as adjunct professor at leading institutions including the Campus Law Center, Delhi University, CBI Academy Ghaziabad, IIM Lucknow, IIT Kharagpur, IDRBT Hyderabad, Nalsar Hyderabad, NLSIU Bangalore, and NLU Jodhpur. Beyond this, Mr. Ryder has also made significant pro bono contributions. He has served as a member of the Government of India's Legal Action Group on the IT Act, honorary legal advisor to the Nepal Telecom Authority, Computer Association of Nepal, and the Office of the Attorney General Sri Lanka. He has also advised the cybercrime police stations in Bangalore and Hyderabad and is an honorary advisor to the Delhi Police Training Center. We are truly privileged to have him with us, and I'm certain his insights will spark fresh perspectives and meaningful conversations. With that, let us get started. Over to you, sir.
Thank you, ma'am. That was very kind. Thank you to Professor Gupta, to Law Teachers India, and of course to Integral University for the invitation, which I was honored to accept immediately without any um, delay whatsoever. So, what I will do is that I have some speaking notes which I will share on screen. Um, can you see my screen? Is it all right, ma'am? Is it being
It is,
shared?
yes, sir, it is visible.
Sure, super. And I will now try to um, complete a little struggle with making sure that this is in the presentation mode. Just one second. Yes, so here we are, and we are, of course, to discuss artificial intelligence, robotics, legal issues, technology, innovation. So this is quite interesting recipe of a number of things, and I will try to make it as interesting as possible. Um, Please do feel free to type in any thoughts, questions, anything you would like me to discuss during the next little over an hour that we'll be spending together. Remember that these are my thoughts. I'll be trying to cover as much ground as I can. It's a huge canvas. And of course, these are my views as of date on this day, and could will even change a little bit, I hope, not too much in the future. Um, what I will try to do, and as ma'am introduced a little while ago, I am a practicing lawyer, and I've had the good luck and good fortune of being around now for 27, 28 years in practice. I'm in my 28th year, and I was lucky to be or to join practice at a time when technology law itself was new. So, what I'm going to do is, with your leave and permission, is to go through the notes that I've prepared and look at the regulation of artificial intelligence, robotics, through the lens of what has happened so far, because we have achieved a lot globally and in our country as well. We've achieved a good deal in terms of giving a robust mechanism for law enforcement in cyberspace. And a lot of those lessons can be taken and applied in the realm of artificial intelligence and robotics. Thank you all once again for the kind welcome. And let's go ahead and start this discussion. So, moving on, we are looking at multiple parts. We are looking at technology, law, and policy, its constituents, what we can learn from the journey in tech regulation so far, understanding facets of intelligence and artificial intelligence, and of course, uh, innovation within AI, and of course, AI's impact on innovation and intellectual property, the realm of privacy, data, and metadata, artificial intelligence, and weapon systems globally, because that has always been a lingering fear amongst humankind, especially since practically since the beginning of machines, there has been this drive uh, to use them in warfare. So right from the time when we invented our first machines, there was also the seemingly compelling need to deploy them in warfare, and artificial intelligence is no less. Towards the end, I will look at some of the emerging regulatory frameworks, and we are still in the early age of regulation, but there are lots and lots of promising examples. And then, of course, I end the session with uh, a few minor little observations from my years in teaching technology law across universities in India and abroad. So let's start with some of the observations from technology law. because these are very important when we look at the regulation of artificial intelligence per se. One, theme number one, the importance of architecture. And here, when we look at the internet, we look at internet architecture. The very fact that the internet is and was powerful because it is a dumb network. What do I mean by dumb? And it's not a derogatory term, it's to highlight the powerful nature of the internet because it has no barriers. It is not a smart network. It is a network that allows the free flow of information. In fact, we have a sentence that best describes internet architecture. The net interprets censorship as damage and roots around it, which has come to be known as Gilmore's law of internet architecture. It's not a real law, it's just a very pithy and powerful summary of what internet architecture is all about. No barriers, information can flow along the network globally, even through space. So, the internet is powerful because of this simple architecture, which means that for us as lawyers, as regulators, as academia, as policy advisors, we have to look at the impact of that simple but powerful network, knowing full well that any security measure that is placed on this uh, network is an additional layer. Then we look at the early um analysis of how the law will apply. And we have many examples, but I've taken two powerful ones for you. John Perry Barlow's essay on the independent theory of cyberspace, and David Post and David Johnson from Stanford in their famous article, Law and Borders: The Rise of Law in Cyberspace. Both, in different ways, celebrate the unique nature of the internet, and one celebrates, one despairs that the internet cannot be regulated and that a new law would have to emerge for cyberspace. Something which is dealt with by Yochai Benkler when he looks at his theory of layers. And he says that the internet is a medium, and any medium can be regulated by its layers, which are the physical, the digital or code, and content. And further, moving from Benkler, you have Lawrence Lessig, who says, well, for the internet at least, software, code, programming is going to work along with law. And we all know his famous work, Code and Other Laws of Cyberspace. In one of my books, I have a chapter which is titled Regulating Indian Cyberspace, which again looks at the role of technology and law put together. So we have regulation working with technology. So code plus law. So our first theme is internet architecture. Our second theme is code plus law, which is taken to its limit or logical conclusion by John Goldsmith and Timothy Wu in their book, Who Controls the Internet? The Illusions of a Borderless World. Where, if I summarize it hastily and clumsily, the central thesis is that if a national government wants to, it can control the internet with an iron hand using law plus technology or code plus law. And they give numerous examples from the People's Republic of China, where the government has used technology and law to control with an iron hand, right from the Tiananmen Square revolution or rebellion down to modern day China, with jokes about the great firewall of China and other things, but their work is interesting because it highlights numerous case laws, particularly from China, which go along with the theme that there can be strict and powerful control in code plus law. The next is the evolution of our law, and we've seen it play out over the last 25 years. This year in October, the IT Act will be 25 years old. And what has it done for us? What is the use of the IT Act? And one of the powerful uses has been functional equivalence. And mind you, the word functional equivalence does not appear in the IT Act at all. It's in the preamble to the UNCITRAL Model Law on Electronic Commerce, from which a large part of our IT Act has been modified and adapted. So, we as practitioners, as academia, need to understand the role of the medium. Is it incidental? Is it relating to content? Is it relating to the integrity of the system? And there we look at regulation. Our evidence law, again, influenced and amended in sync with the Information Technology Act, has given us a very powerful presumption of the admissibility of an electronic record. So you have the evolution of case law, very interesting, which gives a robust framework. What is my submission here? My submission is that artificial intelligence now comes into this ecosystem. This ecosystem of internet architecture, this ecosystem of law plus technology, this ecosystem of the Information Technology Act and many, many national regulations around the world, and of course, a robust framework in evidence law. Now, if we move on to the next big theme, the next big theme which influences us is the platform and intermediary liability. And in my submission to you, ladies and gentlemen, this evening, it is perhaps the most powerful legal fiction of our times in the last 25 years. We've seen numerous legal fictions as students of legal history. One of the most remarkable being 500 years ago, approximately, the birth of the company. The, the fiction of the independent corporate identity. Similar to that has been the fiction of the platform. On the screen before you, you have uh, the first bullet point, which hints at it. It says the 26 words that created the internet. Obviously, these 26 words did not create the internet. But what did it do? It created a shield around internet service providers. And those 26 words became powerful shields for a small bulletin board, for a small business which was hosting content, and it protected them from any third party liability. So if I were a small website called MySpace or Orkut or Facebook, I would be protected against liability arising of or from a post put up by someone else. So, what are those 26 words? Let's quickly go across them, and they are on the screen before you. No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. These are the 26 words which put a shield around all bulletin boards, all websites, and made them immune or protected from liability. And we've seen this law evolve in India, right from Avnish Bajaj versus State, the Bazi case, to Shreya Singhal, which laid down the framework of protection, MySpace versus Super Cassette Industries, and a number of cases which looked at where a website may not be classified as an intermediary in Christian Louboutin versus Nakul Bajaj. So you have a robust framework. Now, many of these IT and especially artificial intelligence systems will arise on and from platforms. In fact, AI tools in cyberspace have now, for the past few years, been used on these platforms. So, platforms become first test cases and disseminators of artificial intelligence and bots, which were actually forerunners or um, robots as we know them. The bots for which make you, which are the reason why you have to type in certain things just so that the machine or the software can identify that you are human. So, into this context comes artificial intelligence. And we look at intelligence itself. I was a law student in the year 1996 when Deep Blue, an IBM machine, defeated the then reigning world chess champion Gary Kasparov. And most of us were shocked. We said, how can that happen? Does it mean that computers are now more intelligent than human beings? But a little research into the match and the framework itself reveals two things. One, that Deep Blue contained in its memory or data bank every single chess game ever played, which was recorded. So you have a machine which can retrieve millions of chess games which are recorded in its data bank within a split or milli or nanosecond. Second point that most people forget is that Gary Kasparov himself worked with IBM to create Deep Blue. So Deep Blue was a product of human intelligence. So Deep Blue knew how to anticipate moves. And when Gary Kasparov had a rematch with Deep Blue, it could get the better of Deep Blue. He could defeat Deep Blue in one of the matches, or at least escape with a very creditable and honorable draw because Gary Kasparov made mistakes, intentionally, of course, which a grandmaster at his level would not or never make. So uh, that's one footnote. David Schenk, a psychiatrist, wrote one of the most interesting books on the history of chess called The Immortal Game. But David Schenk's idea was not to write a book on chess history. His main aim was to write a book on training a chess player. And David Schenk's prime question in The Immortal Game is, are great chess players born or are they made? For most of you esteemed members on this discussion today, your main question and mine, as someone who is also responsible for training young legal students and lawyers, both within my organization and at law schools, our question is, are great lawyers born or are they made? And obviously, the answer is well known to us. The answer is a combination of both. Born in that they must have basic natural intelligence and an enthusiasm to learn, and made in that they must have the right kind of mentorship. So that is true for a human being and a machine. And that is true for any mind. It needs guidance. Intelligence was determined in computing terms in the Turing test, based on a paper published by Alan Turing titled Computing Machinery and Intelligence, in which he put forth a theory which has come to be known as the imitation game. A computing machine is intelligent when it is able to fool or convince another human being that it is interacting with a human being. So, imitation is the highest form. But we all know that machines can imitate blindly. In the short story, The Game, Anatoly Deniprov has this situation where students, math students in a stadium, are trying to create a sentence. They don't know what they're trying to do actually, with zeros and ones. And the code is passed around the stadium with minor improvements. And what is the code? The code is basically a sentence in Portuguese which needs to be translated into English. And one of the students gets a bad headache and or falls asleep, and the end result is the sentence on the screen before you: the greatest goals are achieved through minor but continuous effort. But because the last person had a headache and fell asleep, the sentence reads "ekit," which makes no sense. So what's the idea here? That intelligence is sometimes disguised as what it is not: mere continuous coding or mere um, zeros and ones. And John Searle takes it up in his paper called The Chinese Room. Again, all of these papers and materials are available on the internet for anyone who wants to read. You just enter these keywords, The Chinese Room by John Searle, and you'll get the entire paper. And the paper's based on a premise that two computers can converse with each other in machine language translated into Chinese without knowing the Chinese language. And this is true for all languages, which comes brings us to the main idea: what is intelligence? Howard Gardner tells us that there are multiple intelligences. Howard Gardner is a leading psychiatrist. Today, he's 90 plus years old, worked as a professor at Harvard for many years. And he says that intelligence as a concept is limited because there are many types of intelligences. There is neuromuscular kinetic intelligence, there's interpersonal intelligence, there's emotional intelligence, um, and there is cognitive intelligence, which is the ability to recall vast sums of or vast amounts of data, which computers are good at. So, what we are looking at in terms of AI is what I term unhuman intelligence, not to be confused with inhuman intelligence. It is just that they think in terms of data, logic, patterns, and rules, which is unlike a human being. And therefore, at this stage, it is important for us to have important, verifiable, creditable human oversight of machines, and to ensure that machine systems are transparent and accountable. And one of the most important areas for us to recognize is bias. And here we come to our own bias. First of all, that I do not mean bias as necessarily a negative concept or a negative idea. All I mean is a preference, a leaning towards. But I I recognize my biases? Am I aware of them? And because we as humans are the only animal on the planet which can accept, evaluate ideas, even opposing ideas, and then either completely accept, partially accept, or even reject them. And this is the thesis of Roger Martin's book, The Opposable Mind. Uh, the human mind can evaluate, accept, hear things which they do not agree with, and therefore recognizing bias, recognizing what we do not like, appreciating data, and of course, evaluating conflicting thoughts which may or may not rest side by side. For example, in the movie Pirates of the Caribbean, Jack Sparrow tells Will Turner that you can accept or you must accept that your father was a pirate and a good man, or a pirate and a good father. Can a pirate be a good father? Because being a pirate and being a good father might at many times be uh, exclusive of each other. Just as Ratnakar was both a dacoit as well as a good family man before, of course, he turned completely to the good side and gave up, thanks to the insight he got, gave up the path that he was on professionally as a dacoit. So, bias is something that we need to look at, to evaluate, and to ensure that we are on the right path in a technological way. Someone said Robin Hood. Yeah, I mean Robin Hood, I suppose also, but I don't know anything about, except of course that according to legend, Robin Hood did like Lady Marian. So yeah, you have many examples of people who may have been in a conflicting role. We all have multiple identities. For example, I am at the same time a son, a husband, a brother, a father, a friend, a colleague, and many a times these things are absolutely independent of each other and not in conflict. That, but on occasion there might be a conflict in one of these roles. And that brings us to the important theme of mentoring and teaching AI systems the way you would mentor and teach a young mind, which many of you esteemed members do. Our applications in law, and very few people might remember that Gottfried Leibniz was the inventor of calculus, along with Sir Isaac Newton, was both a mathematician and a lawyer, and wrote famous papers about 150 plus years ago, nearly 200 years ago, on how maths can improve the law. And data, the analysis of data can definitely improve many aspects of the law. And the greatest benefit that we have from technology, perhaps, which I have seen develop in my professional lifetime, has been the search. Because I am from that generation which used to search through Supreme Court cases using digests, and also we also had to read the entire judgment. Today, you can do a Boolean search based on keywords, and that's just scratching the tip of the iceberg. Legal governance, automation for legal data, document review. I mean, right from comparing documents to uh, coding, which allows you for prediction. So, what do we have? We have data analysis, which can help us in legal and policy decisions. Regulating artificial intelligence, what uh, are we regulating? We already have laws that help us regulate parts of this puzzle. I spoke to you about the ecosystem, the architecture, the rule of law, and technology. And here we come to another very simple example in Thornton versus Shoe Lane parking. A 1971 House of Lords case involving our good friend, the legendary Lord Denning. And in this case, a gentleman called Thornton was upset because he had to interact with a parking meter placed outside or near his apartment building. And his fundamental question, and this is again a bad and a quick summary, was that how can I, a human being, interact with a parking meter? It is not possible for me to enter into a contract with a parking meter. Lord Denning reminded him that he wasn't entering into a contract with a parking meter, but it was possible for a parking meter to be an agent of the company. Just as when we go online to Flipkart, Amazon, Zomato, anywhere, we are interacting with bots. And it is based on this framework. So my submission is that for much of the regulation, we have an existing framework. We have an existing framework for product liability and consumer protection. We just need to balance and fit in AI and robots. Similarly, for professional ethics and liability, healthcare providers using robots, where is there a path? What kind of errors can be made? And a well programmed robot might be able to perform surgery in the near future better than any human being, because it is unlikely to have the kind of emotions, tiredness, bias. And there, of course, issues. How do we regulate this, and what kind of considerations do we place, or rather, how can we work together and uh, integrate algorithms and law? One of the huge areas of interest when it comes to artificial intelligence is data and metadata, which is, as we all know, data about data. So it is not robots and AI systems which are collecting data. Data collection has been ongoing at a rapid pace in the last 2 or 3 decades. Data has been collected like nothing and never before. In fact, in my early interactions with the Ministry of IT, we were discussing with service providers as to how data could be stored. And telecom service provider would tell us, sorry, it is not possible for us to keep data beyond 3 or 4 months. And now we have places like the legendary Bluffdale in Arizona in the United States where exabytes and exabytes of data are kept on farm. Now, this data is being analyzed backwards in time. That means data collected 5, 10 years ago is now being put through machines to look for patterns. That means we have tools to handle what I termed earlier um, unhuman thinking. We have a framework in Puthaswamy in individual control, transparency, respect for context, security, access and accuracy. Our data protection law and data protection act and rules will have to stand the test of Puthaswamy. On innovation, and these are again my views, as biased as one can get, but I do believe that at the moment when we talk about artificial intelligence, robots, algorithms, we are talking about tools. And right now, I at least personally believe that tools do not create. It is a human mind that creates, and not something that is programmed. And therefore, the intellectual property guidelines need to look at, already globally, we have patent related guidelines. We have interesting cases from State Street Bank to Alice on whether the output from algorithms can be patented or not. But what some of the questions we'll need to analyze are: does the law contemplate a non human creator? Who owns the intellectual property in a work created by a machine? What about the bundle of rights that come with copyright? Moral rights, revenue, jurisdictional issues, royalty? And do we see this artificial inventor? Maybe not at present. Maybe because intelligence hasn't surpassed or integrated itself the way human intelligence is integrated. But at the moment, when we talk about AI or talk about robots, we are talking about tools which are created by human beings. And therefore, my humble submission at the present day is that tools do not create, humans do. When we talk about human creation and innovation, we look at the path of the inventor. And this is important for us to know because we are not only intellectual property law teachers or practitioners, we also work with inventors. And the path is very this is not the path for every inventor, but for most go through this. Even when you're writing a research paper, you have the inspiration, the focus. And focus is, some people are fantastic, some people like me who are perpetually distracted have to try harder. Not everyone can be an Arjun who, when the Guru Dronacharya tells him to focus, he says, "What do you see?" He says, "I see the darkness in the eye of the bird." He does not see all along. When I was a small boy and I read for the first time, the book said, "I can see the eye of the bird." But what Arjun says in the original text is that I can see the darkness in the eye of the bird. So he has extreme focus. The sponsor, Guru Dronacharya, would not have come if he had not got the good salary that the Pitama would offer. So the sponsor of the Kauravas and the Pandavas, the Pitama, is extremely important, like capital. The faith of the person, the faith, and of course, fear and doubt. Asking the questions and being and doubting. At the eve of the battle, we all know how Arjun had his doubts and how he was able to. He was lucky, fortunate for himself and for all of humankind that he was able to ask those doubts from the one being, the one Lord who had the answers. So the innovation and creative process is very important for us as lawyers, as academicians, as policymakers to understand. And of course, I have a reading list. I know that time is running out, so I'll be a little fast. Uh, Peter Bernstein, Against the Gods, the remarkable story of risk, very interesting on the evolution of the legal tools we use to handle risk. And his book is amazing on the insurance industry and can be linked to how we manage risk across commercial transactions even today. All intellectual property is necessarily international intellectual property, and that's Paul Goldstein's um, thesis. If you have a great idea, where would you keep it? Not in your attic. We, of course, in India don't have attics. We have storerooms, some of us. Um, So Kevin Rivet, the chief innovation and IP officer at IBM, says, "Do not keep your Rembrandts in the attic. Get your Rembrandts out of the attic." Rembrandt was a Dutch painter. His paintings are one of the most expensive now in the world, along with Van Gogh, Picasso, and the others. In the Indian context, if you had a Gemini Roy, a Gaitonde, a Raza, where would you keep it? You would keep it in your drawing room, or at least if I had one, I would sell it and retire. So, what would you do with your ideas? And an ad at the start of my career, I saw an ad by one of the larger software consulting companies, which had a cup of coffee, and the slogan was, "Your idea is like a cup of coffee, it won't stay hot forever." What would Edison or Einstein do in the boardroom? Organizing for intellectual property awareness. Intellectual capital, says Thomas Stewart, beyond IP. The creative economy, says John Hawkins with an O, how to make money from copyright. And owning intellectual property is owning the future, says Seth Sherman. And I'll go quickly over some of the interesting themes. First, of course, is purpose. Bruce Pandolfini, a chess teacher in the United States, wrote this fantastic book called "Every Move Must Have a Purpose." It's only 100 pages. I would recommend it even if you are not a chess player. If you don't have a purpose, then you're like Willy Wonka's boat in the in Charlie and the Chocolate Factory. We know have no There's no knowing where we are going. Taking the risk. Marshall Phelps, the chief innovation officer of Microsoft, wrote a book called "Burning the Ships," a reference to Cortez when he lands in South America and he tells his soldiers to burn the ships. He says, "We are going to take the Aztec and Inca gold back. Then only will we leave the shores of South America." Not a very noble idea, but you can see the determination. Watch the board, not the opponent. Be humble. Even if you're winning the battle, like Odysseus, when he succeeds in getting the better of this giant called Polyphemus, and till then he hasn't told the giant his name. He blinds the giant and he's running out of the cave when the giant asks him, "Who are you, no man?" Because till then he's told his name as no man. So instead of running away quietly and getting back on his ship, Odysseus stops and he says, "My name is Odysseus, son of Laertes, sacker of Troy," basically giving his entire CV. Like what was read out to you. I'm sorry for people who got bored. Here, he's asking for trouble because if you are low key and humble, it's always better that way. The organization must learn and unlearn, and the quest, uh, buying intellectual property. And this is very interesting. Why costs do not matter and why value always does. So when Mark Zuckerberg set up Facebook, he was looking for patents. He didn't have any. Where were the patents? With the earlier social media sites, Orkut, MySpace, even with IBM, Microsoft, Yahoo. So Mark Zuckerberg just went, got his engineers to create a shopping list and went out and bought the intellectual property. Or you can create. We do IP harvesting workshops for clients where we help them take the idea from the concept stage to a patent application, and that's important as well. Intellectual property, had there been no copyright, had there been no technology, there would have been no intellectual property at all. And of course, IP is bolstered by contracts and contract management. We encourage our clients to look at contracts as powerful tools to strengthen legal relationships. And of course, the intellectual property life cycle is all about defending the idea, reducing cost, or creating a licensing chain, capturing the value of intellectual property and using it strategically. And that is why the companies with the largest patent portfolios also are more valuable on the stock markets. Synthesizing opportunities, shaping the future, because intellectual property is a important tool. And when we come to rules, the first rules come to us from science fiction. Isaac Asimov's short story Runaround, which was later expanded to be a Hollywood blockbuster I, Robot, starring Will Smith. A robo may not injure a human being or through inaction allow a human being to come to harm, must obey the orders given to it by human beings, except where it comes into conflict with the first law, and must protect its own existence as long as it that protection does not conflict with the first or second law. So this is a framework from science fiction, which I have taken mixed with the work of Frank Pascal, who wrote the new laws of robotics, and we have ourselves a set of broad principles. What is it? The first principle is the principle of complementarity or harmony. Robotic systems and AI should complement professionals and not replace them. The interaction should be genuine, not counterfeit or fraudulent. People should always know that they are interacting with a human being, and that interaction should be done with oversight and the necessary transparency. Warfare and conflict, robotic systems and AI should not intensify zero sum arm race. There should be no arms race based on uh, uh, what we have in terms of um, robotic and also decision making. More than the weaponization of AI, who makes the decision? So we cannot say that there's some really wicked sort of chaps hiding out somewhere in a cave, and we can send a drone and let the drone make a decision as to whether it should blow up the cave or not. That is completely unacceptable. No matter who the and no matter what is happening, the rules of natural justice, of warfare, of the relevant conventions should all be factored in when it comes to warfare and conflict. And definitely, no robotic system should be allowed, even remotely, to make a so called decision on their own. Which brings us to the last point, which is transparency and accountability. Not only should there be transparency and accountability, but should always let us know, advise us, and indicate the identity of creators or controllers. The European Union AI Act is one of the uh, big and perhaps one of the only major laws available to us, which categorizes systems into high risk systems, which uh, again underlines the need for creativity and says that high risk systems should be transparent, traceable, and should necessarily document technical aspects of risk management, uh, testing, supervision, penalties, and of course, the penalties are serious as in most of these laws, and of course, a complete ban on certain practices which are categorized as high risk practices. Um, so I've actually come to the end of the discussion. A few of the things which I would, these are just my notes on teaching, on looking at um, the development of syllabi, and of course participating in uh, the governance of a law school, and of course looking at how we can prepare lawyers and law students in this era of competition, which comes not only from other humans but from machines as well. So I'll be happy to answer any questions. I'll take up there was a question on, yes, Dr. Indra Vijay Singh. Um, The working of AI is based on maths. Law is totally different. If 100 crime happens, all have a different story. How will AI solve them? Well, we go back to what our esteemed colleague, of course, he's no longer with us, um, who wrote the paper 200 years ago, Leibniz, on computational maths and law. Leibniz was both a lawyer and a mathematician, and he believed that a lot of legal problems, not all of them, but a lot could be reduced to principles. I am not saying that um, AI can solve it. I am saying that AI can be a very useful tool, and logical thinking, which applies to law, is also can be mathematically deployed. So the so maths and algorithms can be useful tools for lawyers and the legal community. Again, as several times, including recently, our Honorable Chief Justice of India has reiterated our feelings as a community that definitely at the stage in which we are, we cannot be, we cannot think of human thinking, principles of justice, emotions, all being replaced by machines. But yes, machines can be very important tools of data collection, aggregation, so on and so forth. And we have another question, and I'm so can we have an Professor Avnish Bharti says, can we have an AI based, oops, it went
I would
can
like
we
to
have
take a
an
oral.
AI?
I'm sorry.
So,
I would like to. Sorry,
Yeah,
Anushka,
sure,
over to
sure,
you.
sir, sure, sure. Because I was,
Yeah, we
having
can
my
take
own.
up maybe oral question. No, no. Abhimanyu,
Sure,
are you
sir,
there? Abhimanyu?
sure.
Abhimanyu, you raise your hand. Abhimanyu, would like to ask any question? You
Am
raise
I
your hand.
audible? Am I
Yes,
audible?
audible. Audible. Over to you.
Sir,
Yes, you are.
there are a couple of questions that I have in my mind in regarding to what you were discussing. So my
Sure, sir.
first question is regarding the point of bias. Like when we know that already the systems are like when we know that input data is already so much biased because the one who are collecting data on the ground have their own biases stemming from their own preconceived notions. Do we actually believe that there is a proper way to remove the biases that might transpire into the system because of those input data that we are going to feed into the system?
No, I think that's a fantastic question, and that is something that we will definitely struggle with. Um, for example, the way we look at the world has changed in the last few thousand years. And by few thousand, I mean like which is short in the history of the of Earth. In the last 10 to 15,000 years, a lot of notions that we've had are changed. So when you look at bias, what we can do is recognize which way we are leaning. And like I said earlier, not every bias is harmful or bad or negative. It is just a leaning. uh, and one of the problems is, where do our limitations come from? Our limitations might come from understanding. Our limitations might come from language. So I might turn around and tell even a family member, I'll draw the curtains and look outside and say, oh, what a wonderful day. And that person will stand by the window and say, what's wonderful? It's raining. But I like the rain. For me, the rain is wonderful. So there's a limit to what nice, lovely, wonderful means for me versus somebody else. So biases, how are they to be mapped? How are they to be measured? We will have to find a common ground. For a lot, the common ground is emerging. You will see the case law of the last 50 years, 100 years, and you will see the way the criminal justice system has evolved. And if you look at some of the early judgments of 100 years ago or 200 years ago, you would call those judges biased. So, does it, uh, our main thing is that are we able to integrate human thinking? Are we able to handle conflict? And are we able to see how the decisions are being made? Once we are able to see the principles behind those decisions, then we are able to evaluate them and we are able to correct ourselves. And we are lucky to have these machines which can also point out the biases. So, and of course, like everything else, will human supervision will be required, because when we deploy them, then we will only come to know how it is working. So all of this will have to happen. Human beings will have to, as a collective community, will have to mentor these systems before they achieve any level of noteworthy level of perfection.
Thank you so much, sir. It was excellent point that I was able to miss. Second major question about is you must have heard about the clear views.
Abhimanyu, sorry for interruption. We have to take other question also. So I should stop with
So,
this.
so one more question. That's it.
और
So
भी
in
लेने हैं question 2-3. Yes, please, please, please.
okay.
Yes,
So,
yes,
sir,
yes.
the second question is regarding Glukin versus Russia, where Clearview taking doing real time biometric identification systems, like without similar, like this kind of technology is being used in India as well, but we don't have an effective regulation or regulatory mechanism around it. So, do you think that similar AI Act or similar principles of AI Act that is being used in Europe can be also used in Indian context as well?
Yes, again, another excellent question from you, and I can appreciate your enthusiasm. See, at the moment, there are a couple of facets to this, this question and to this debate. One is that, again, are we able to put in place an overall umbrella system? What the EU Act does for us is to point out and highlight broad principles which no one should have a problem with, because most of them are universal. The categorization into high risk, the transparency required. Now, we come to the next thing. We discussed at the beginning, I said that architecture plays a role. The rule of law and technology plays a role. Legal fictions play a role. But also there's another huge factor which plays a role, and that is private enterprise and private business, and private businesses collaboration with the state. So many of these surveillance systems and surveillance economy which we are living in is all propagated by large tech. So we are not, it is not about AI systems, it is about those huge companies which are behind them. It is not that AI can, or what the harm can AI do? Because AI is not some sort of naughty, evil robo lurking around somewhere which is harming people. AI is promoted by big tech, and right now, these big tech companies have become much bigger than what anyone anticipated. The Federal Trade Commission of the United States is grappling with the problem of how to deal with Google. Some years ago, they grappled with the same problem when it came to Microsoft. But here we have the safe harbor shield, which is around these companies, which was initially those 26 words which I told you were there to protect these small bulletin boards from getting sued left, right, and center by anyone because they were offended by the content. But we put such a protection around them that it became like such a powerful kavach which made them invincible. And now the laws, so we are all through the world, we are learning all this. And one of the risks is that we must be able to learn quick enough. My problem is not with, for example, if I were to be critical, we have a wonderful IT Act, and we have had, no matter who and which government has been at the center, we've had a consistent policy on with IT. Every government has supported, every government has gone ahead. But what is the problem? The problem is that we haven't amended the IT Act in 25 years. And for that, and we are scared to say, oh, something is wrong, because it becomes a political issue. Unlike in some countries where people say, okay, fine, I didn't understand technology law. Now I you know understand it better. So let's change the law. So we have to be quick and fast and learn from our mistakes. We cannot expect that there will be no mistakes. We have to learn how to deal with them, record them, move on without, hopefully, without a blame game. Uh, like I said, I cannot answer it to the satisfaction of either the querist or myself because of the time. But what I can do is that I can share my email address with you. If there are any questions that you have beyond this session, also, because I know there are lots of questions. We can, you can message me or email me anytime.
Thank you so much.
Sorry, Abhimanyu. We'll just go to the next question.
Yes, thank you so much for sharing your email ID with us. Uh, I'll just read out the question we have in chat box. There is
Thank you,
one
Manu.
very interesting question from Rahul from Pune. He's asking the recent Supreme Court's order on marital dispute where the wife was asked to do a job as she is educated and demanded 12 crore, but ends with 4 crore flat on natural justice. How come this will be solved by AI as there are contradictions on statements? So it's around natural justice.
You know,
How AI
I'm,
is.
yeah, I'm aware of the of this case, and of course, I don't want to go into any merits of this particular individual case. But yes, we can look at rules, we can look at how this can be looked at in the interests of fairness. The one good thing about algorithms is that they are maths. So 2 plus 2 is always 4, and we can see the equation and how it is working. Now, 2 plus 2 is not always 4 when it comes to justice. Um and one of the for all youngsters here, if there are any law students, so I think I would really encourage you to watch. It's quite an old movie. It came out when I was in incidentally sometime in when I was in college, which was called Murder in the First, and it's about the murder trial of the trial for murder of an under trial who murders within a prison, and the circumstances that gets him there to the prison. So we've had great works across Indian, American, European literature where we looked at under trials and looked at their position. And uh, there are a certain kind of uh, uh, principle of mercy, of justice, that we need to program into our machines, because more and more we are going to be reliant on them. So we have to prepare for that. And it can be solved by AI. And I am the firm believer that an artificial intelligence mind can be trained the way a law student's mind or a human mind can be trained. There are lots of research done on this. Kurzweil's book, How to Train a Mind, is a fantastic starting point. uh, it cannot be achieved in a day. There will be errors. But the good part is that if you look at systems, they will be transparent. The errors will show up. And once these trial runs are done, then maybe we can look at deploying it. Why not? But until then, I think that we are not should not be hasty to praise or condemn anything. We have to allow for a slow adoption. I'll tell you the story. One, I don't mean to bore anyone, but I have been using dictation tools for the last 25 years or 27 years, right from the start of my career. And some of the tools which I used about 25 years ago were really more of a pain. I just could not dictate into a tool. I mean, it was no way that it would not come back with 20 or 30 spelling and grammatical errors. But recently, I've been using some of the tools which are free on the internet, and the commas, the paragraphing have been so precise that it's a delight to use. Now, this doesn't happen overnight. It happened over the course of 25 years, and we watched it happen. So, if that can be for a dictation tool, can you imagine teaching the concept of natural justice and programming it into a machine? It will take time. And make no mistake, my friend, your question is fantastic. But let me answer it in the end by saying that we are just now not even in the stone age of artificial intelligence. What these machines can do, and which brings us to my favorite game, chess, which is that now today there is no human player alive which can beat a chess machine. Every single chess machine is more powerful than a human mind. So, what will have to happen is an integration. We will have to use machines more and more in our lives, and that will make us more powerful. But yes, it is also a scary thing to think about. And I can only tell you that for all of us who are here today and who are interested in this area, we are definitely going to be more engaged. And of course, I look forward, of course, to interacting with all of you again. I'm just hinting to Professor Gupta for another invitation.
Thank you. Thank you so much, sir. And of course, it gets scary when the robot itself is asking you, "Are you human?" So that's where we need to learn. We need to learn to accept and evolve with time. Thank
Every day
you
we
so
have to
much.
face, right? We have to prove we are not a robot. Then we are able to log in. So,
Yes. Yeah. Thank you so much, sir, for your time today and this insightful session. I'm certain the participants would have learned a lot and would have given the perspective, new perspective to for the future of law in new ways. On behalf of Faculty of Law, Integral University Lucknow, and Law Teachers India, I extend our sincere gratitude for your time and expertise. A big thank you to all our participants for your energy and thoughtful contributions. We hope to have Mr. Ryder with us again soon. And until then, let's continue the conversation this session has sparked. Thank you and wishing you all a wonderful evening.
Thank you so much, ma'am, and
thanks.
thank you, Professor Gupta. Thank you for your friendship and thank you for the invitation. I look forward to many such events in the future. Thank you all. Thank you so much.
Thank you.
Thank you, sir.
So, thank you, Anushree. Thank you, participants, for joining. See you tomorrow.
Thank you, sir.